heard appeals in the matter of schools, facility management and others, and the governing body occupies the King College and anor.
So the last word, is it?
Oh, absolutely, my lady, it is. Yes, I just need to respond to the question of mean profits. My lord so kindly reminded me. My lady, as the court will recall, the word mean is an old French word meaning intermediate. And it was the concept of mean profits were introduced to permit or explain an action by a true owner of land against a trespasser in actual possession, back in far off days when actual possession was treated as of greater importance than it is now. And the legal fiction was created that the trespasser held the land as a mean lord, an intermediate lord, under the true owner. There is authority in this court in the 1990s that mean profits may be a restitutionary remedy, and it's been followed since. There's also authority more recently in this court that mean profits may be claimed as a non-restitutionary remedy for ordinary compensation. As far as I know, it's never been argued that mean profits as such could be claimed as damages for trespass to goods rather than trespass to land. I may simply be in ignorance, but I didn't know, I'm not aware of anyone attempting to do that. But I do accept that there is an analogy between restitutionary mean profits in the situation in which that's normally used and the situation that arose here, which in my submission provides some support for the argument that the judge's solution in this case was an appropriate solution. But it doesn't go any further than that.
Thank you. Will you just allow me a moment? Thank you very much indeed.
Thank you.
Mr. Watkins.
My lady, can I start at the outset with a suggestion that my learned friend made about the nature of this claim? And it was said at the outset that this appeal by the college is in some way an attempt to punish his clients. And now I think in fairness to my learned friend, he later accepted that that may well have been a slight embellishment of the point he was seeking to make. But I do need to correct it at the outset. This is a transaction in which both parties are out of pocket. Now, SFM is out of pocket because it incurred costs in connection with the construction of the building.
In excess of 5 million.
Indeed. The college is out of pocket because it paid far more than the value of the use of the building in the entire period to trial. And on the evidence before my lady and my lords, the losses are broadly comparable. Their position, SFM's position, is that it received £3.2 million against an outlay of 5.2 million. So that gives you a 2 million loss. And our position is that the college paid out 3.2 million and received a benefit worth 1.7 million, leaving a loss of 1.5 million. And so it's not a case where one party is in any way seeking to punish the other. The losses are broadly even on both sides, and our case is simply that the losses lie where they fall, the transaction being void. And that is the just outcome on this appeal, and on no view can it be said to be an attempt to punish the other side in any way.
On a very small point of detail, you've both referred to the figure being up to the date of trial. Have I understood correctly that it's been calculated by reference to the date of the main judgment of the 7th of May, rather,
yes,
than,
I believe that's
rather than the trial itself?
My lord, I believe that's correct.
Ms. Statton's also nodding. Thank you.
Now, with that point to one side, I wanted to come to the critical issue that we spent some time on yesterday relating to the finance element of this transaction. Now, my learned friend started by very fairly accepting that the counter restitution principle was engaged in this case in relation to SFM's claim against the college. And what was accepted was that the way that the principle was put was that SFM could not claim restitution from the college without giving back what was received in exchange for the benefit that was being claimed. That was said to be a condition for the recovery. The central point made by my learned friend was that there was more than one exchange in this case, And so counter restitution could not be applied looking at the transaction as a whole, but looking at the many exchanges which were said to have happened. And in this regard, there was an important exchange between my learned friend and my Lord Popplewell, in which my Lord asked my learned friend whether or not it was sufficient for my purposes to show that the higher charges paid in the earlier period could not be treated as exclusively referable to the use during the earlier period. And I would respectfully agree that is sufficient for my purposes, because that would mean that the payments that were made in the earlier period did not relate exclusively to the use of the building in the earlier period, but related to the use of the building from the transaction as a whole. And I did not understand my learned friend to disagree with the proposition that was put to him by my lord, but he put forward a new argument in answer to it, which doesn't feature in my respectful submission in the judgment or in the skeletons. And what my learned friend said was this, that in fact in this case there are two separate exchange transactions going on. The first relates to the use of the building. The second related to the loan element in the transaction. And as I understood the argument, in relation to the first transaction, alleged transaction, the use of the building, my learned friend accepted a need for counter restitution. But my learned friend said that the benefits conferred on SFM in relation to the loan element could not be netted off against the element of the transaction relating to the use of the building. And so my learned friend's answer to my Lord Justice Popplewell's question was to say that the financing payments in period 1 did not relate to the use of the building at all. They formed part of a different exchange or a different transaction. Now there are 3 points to make about this. The first is it is not the basis on which the judge approached matters, because what it involves is dividing up each of the annual payments into the use element and the financing element. And can I ask you please just to look back at the judgment just to make good that point. In the core bundle, behind tab 9, at page 259, and it's paragraph 24.
This is the consequential judgment.
The consequential judgment, yes. And it's a paragraph with which we're now very familiar. And in paragraph 24, the learned judge says the rent instalments paid by the college were referable to and conditional on the enjoyment of the use of the building during the contract years for which those payments were made. And that is plainly a reference to the total payments that were made in each year. There is no suggestion in this paragraph that that was intended to be a reference only to the proportion of those annual payments which was equal to the market value for the relevant period. Now, the second point flowing from this is that my learned friend's new argument involves a concession that the financing charges in the first period were not referable to the use of the building during the first period. That must necessarily follow. And it must also follow from that, adopting the same logic, that there is an implicit acceptance that the approach of the judge in that paragraph was not correct. Now, the third point, and perhaps the most important, is that in my respectful submission, this new point is not a good one. The financing in this case, the financing was being provided to the college for a specific purpose. And that purpose was to enable the college to use a highly specialised building as a sixth form college. And the college obtained the use of the building during the period from September 2013 to the date of judgment. And in return, it paid the annual sums which comprised financing costs. And there is no basis in my submission for treating the financing element as some distinct part of the transaction that had nothing whatsoever to do with the use of the building. The proper analysis is that it formed part of a single transaction in which the college acquired from the outset the use of the building in return for annual payments comprising financing costs. And the proper analysis is therefore to apply the counter restitution to the entire transaction as a whole, and not in the way that my learned friend now seeks to put the point. And in my respective submission, for that reason alone, one ends up in the position for which I contend. If the starting point between us is that counter restitution does apply to SFM's claim against the college, and if it is accepted that the benefits conferred in the first period did not relate exclusively to the use of the building in the first period, then it must follow that one looks at the transaction as a whole and does not parcel it up in the manner for which my learned friend contends. And that would lead to the answer that I urge upon my lady and my lords. Now, the next point I wanted to make concerned the significance of the invoices to which my learned friend...
Could I just ask you about that last submission you made, which is that it would lead to the answer which you contend? Suppose you're right, and you treated it exactly as the judge did, which is setting it off against a year. It was only in September 2013 when your client couldn't afford to pay, and everyone then realised it was a void contract, that you then net everything off to that period, and it's just dealing with the period after that that the judge is looking at, which is different in terms from the exchange transaction that was entered into at the beginning. So you don't need to divide up financing and use. You just say, this is what it was while everyone thought the contract was valid, and after that, things change.
In my respective submission, that would not be the correct way of looking at it.
Because?
In this case, what one has, the nature of the transaction and the nature of the exchange between the parties does not change depending on whether or not one party is making payments under the contract. And so the college's use of the building remains the same. It is still a use arising out of the transaction between the parties, and the payments made in the earlier periods continue to be related to its use throughout the relevant period.
Well, not really, because the college, on the judge's findings on all the misrepresentations claim, were acting entirely innocently and properly. And it was only when they couldn't afford to pay that they investigated, and the same as the other side investigated. And then everyone realised that you had a void contract. So actually you had their kit and you had no right to use it. And that's different from acting perfectly innocently on both sides, where there's restitution and counter-restitution. Is that not a bright line when everyone realises the contract actually wasn't what they thought it was?
And in my respectful submission, no, it isn't, because that simply reflects the point in time at which one party ceased to transfer benefits to the other, but it doesn't affect the quality of the college's use of the building, because on the judge's findings, the contract was void from the outset. The nature of the transaction didn't change when the college ceased to make payments. From the very outset, the college had no right to retain it under the contract. And so one can't draw the line where my lordship's example puts it in my respectful submission.
Thank you.
I was going to say something very brief about the invoices, which in my submission is a red herring. And my learned friend sought to support the approach of the judge of looking at it year by year by reference to how the invoices described the payments, and my lady and my lords were taken to parts of the judgment where that's recorded. And there's just two short points to make in relation to that. The first is there is no suggestion that the judge placed any weight on that by way of evidence for the purposes of his analysis of the counter-restitution point. In those relevant paragraphs, the invoices are just summarised as part of the process of working out what the total payments were made, what the total amount of the payments was made. The second, but probably the most important, is that the invoices are of no assistance because it is now accepted on common ground that part of the payments for each year related to financing costs, not to the use of the building. So the invoices simply reflected the fact that the contract required annual payments. But they tell you, in my respectful submission, nothing about the substance of those payments. And indeed, that is a point which we have debated at length, but it is not a point that the invoices answer.
You say it's common ground that part of the payments each year are related to the financing costs, not the use of the building. Is that right? Do you accept that part of the payments in the earlier period were referable to financing costs and not to the use of the building? I had thought from your earlier submissions that that was the very proposition with which you
No, it is common ground that at least I understood my learned friend to accept, is probably the more accurate way I should have put to the point, is that the payments in the first period comprised an element of financing costs. And my learned friend accepted that.
But you don't accept that. That's not common ground.
No. Now, my lords, the next point concerned the proper approach on this appeal to the question of severance. And my learned friend submitted that this was an evaluative issue with which this court should not interfere lightly. And in my respectful submission, that is incorrect. One is dealing here inherently with the characterisation of the relevant exchange transaction. What was the exchange transaction? And in identifying a transaction, that is a question for the court and a question of law. And my lady, my lords, one sees that also coming out clearly from the authorities to which I've referred on the question of severance in my supplemental skeleton. I referred to that in opening. My learned friend did not go to those, and so I won't develop the point any further. Now, the next point I wanted to make concerns a familiar argument. Does it make a difference that this case does not involve the payment of money? And my learned friend repeated his submission that he previously made to the effect that counter-restitution may depend on the type of benefit conferred under the contract. And so where payments go both ways, it may be right to apply the principle, but where instead of it being money, it involves money on one side and the use of an asset on the other, the position may be different. In the end, it was unclear how far my learned friend sought to press that point when questioned by the court, and that in my submission it remains wrong for the reasons I gave in opening. In principle, there is no difference between an exchange of payments and an exchange of money for use of an asset. In both cases, there has been a mutual exchange of a benefit, of an enrichment. the same legal principles apply to the unwinding of that exchange. That may give rise to questions of valuation, which need to be resolved in due course, as to what the benefit of the use of the building was. But the learned judge resolved those questions in this case, and there is no appeal against that point. So one knows the value of the benefits on both sides. And the relevant question is, do they need to be netted off against one another, applying the counter restitution principle? And the answer to that question cannot depend upon what it was that was conferred under the contract. My lady, my lords, I then need briefly to address a point that my learned friend made about the Westdeutsche decision in the Court of Appeal, and that is Authorities Volume 1, tab 7. And it's page 236C to D of the bundle.
I'm so sorry, could you give me that page again?
Yes, 236C to D.
Thank you.
And could I ask my lady and my lords just to reread that passage, a single paragraph. On the basis of that, my learned friend made the submission that Lord Justice Legate was here saying that a different position would arise in a borrowing contract like this one. Now, it's apparent that Lord Justice Legate said that on the basis of the decision of in Sinclair and Brougham, which one sees referred to in that paragraph. And that is was a highly controversial case, which decided that one could, where a borrowing contract or deposit contract was unlawful and ultra vires, the loan couldn't be repaid because that would amount in substance to enforcing a void contract. And that is what Lord Justice Legate is referring to here. And then that principle was overruled in Westdeutsche in the House of Lords. And it's no longer good law. So it is no longer good law that one cannot unwind an ultra vires borrowing contract. And so claims for a void borrowing contract and restitution are decided in exactly the same way as any other case. And indeed, it would be absurd if a borrowing contract were void, but no recovery could be made of the funds under that contract in unjust enrichment. The only break on the principle is that the unjust enrichment claim cannot be invoked where it to do so would be inconsistent with the policy underlying the relevant statutory prohibition. And now that is not a principle that is engaged in any way here.
No, there'll still be limitations based perhaps on illegality or public policy where they apply to the circumstances of the case.
My lord, precisely.
And that's really all the court at this stage was doing by reference to Sinclair and Broome.
My lord, yes. And so that doesn't arise in this case whatsoever. Indeed, the position for which I contend is the most consistent with the statutory framework in which we are operating. The college did not have capacity to enter into a borrowing contract. It simply didn't. And so it would make no sense for the college not to be able to recover any amount of borrowing payments which it had paid over. The transaction ought to be unwound, and that is what the counter restitution principle seeks to do. then brings me briefly to the topic of mean profits. And I'm grateful to my learned friend for the introduction to that topic. Now, there is my learned friend accepted rightly that mean profits claims can be analysed in one of two ways. One is a claim for compensation for damages arising from the wrongful use of the property or occupation of the property. The second is a claim in unjust enrichment or for restitution based on the benefit received by the party in occupation. And the claimant has to elect which of those two remedies to pursue. And in the present case, the election was made to pursue the restitutionary claim, and although not described as a claim for mean profits, that is what we are dealing with, a claim for restitution arising out of the use of the building. And in relation to that claim, the ordinary principles of restitution apply, and those are the ones that we have been debating here. Now, I'm not in a position to speculate as to how a compensatory claim may have been framed. I also wasn't appearing below, so I won't enter into that debate, but it's sufficient to say that that isn't a claim that was brought in these proceedings. And so my respectful submission that the mean profits point doesn't take us any further on this appeal. It doesn't provide any independent support for a refusal to net off in the second period, because it's common ground that we are here concerned with a restitution claim for the benefit of the use of the building in that second period, to which the ordinary principles apply, including the counter-restitution principle.
Well, Mr. Salzado submitted to us, tantalisingly, that there was Court of Appeal authority for treating a claim in mean profits as a claim, as a restitutionary claim, and there was also Court of Appeal authority for treating it as a compensatory claim, but he hasn't told us what those authorities are.
My Lord,
And,
the answer...
I don't know whether you're in a position to say that it's clear that a claim for mean profits is and is only a compensatory claim.
No, it certainly isn't only a compensatory claim. What I can show, my Lord and my Ladies, is a summary of the Court of Appeal decision to which I believe my learned friend was referring in the Benedetti case, which is in the bundle. It's volume 2, tab 19, page 575. And this is the judgment of Lord Clark. Now, of course, this was not a claim for mean profits, but the mean profits cases were addressed, and one sees from E through to over the page at B certain passages from the Court of Appeal, and the one I wanted to refer to particularly was below the letter G. My Lady, my Lords, I refer to that simply to make good the point that claims for mean profits can be analysed in one of two different ways: compensatory on the one hand, or restitutionary on the other, and the claimant needs to make its election.
Mind you, it probably wouldn't have led to a different result in this case, because I mean the expert evidence, the unchallenged expert evidence in the trial was just from a surveyor saying this is what a yearly rent would be for this 250 rising up to 270 later. In my respectful submission, it may not be as straightforward as that, because in the present case, what that question was concerned with was that evidence was directed to the question: what was the value to the college of the use of the property? Now, a compensatory claim would have to ask the question: what loss has been suffered by the landlord, by SFM in this question, through being deprived of the use of its property? And that may give rise to questions as to whether there was indeed a market for an asset of this type, how readily it could have been relet into that market. And that debate just didn't begin in this case, in my respectful submission.
I think on the judge's findings, the answer would have been 0, because he found not that it had no residual value at the end of the 15-year term, but it had no residual value ex situ by the date on which the parties realised that the contract was void.
Lord, indeed.
If I remember correctly, I think that was the judge's finding.
So one can envisage that a compensatory claim may have given rise to complex questions. And it may be for that reason that many parties often choose to bring the restitutionary claim, because the only relevant question there is not could the owner of the property have relet the building, but what benefit did the defendant get from being in occupation? And that is a question that doesn't involve any inquiry into the claimant's position. My lady, my lords, that was all I wanted to say on the subject of mean profits. And indeed, in all, save to say that I do have a list of the editorial board that my lord asked for. I don't know the protocol for handing things up at the moment. I could instead email it to your clerks if that would be
Please,
better.
that would be very helpful. Thank you, Mr. Watkins.
My lady, my lords, unless I can assist any further.
No, thank you very much indeed.
My lady, may I just crave indulgence to say one short thing, which is simply my learned friend made the point in relation to my submission about the exclusion of borrowing contracts by reference to a housing laws authority that was then overruled, and said in that context that there was no such policy issue relevant to this case. And I simply remind the court that I did refer to paragraph 4284 of the judgment, where the judge does indeed consider precisely the issue that my learned friend said was not an issue in this case.
Mr. Watkins, I'm not playing bat and ball, but is there anything you want to say in response to that?
I do. So in relation to that question, the point the learned judge was making in that paragraph concerned how to assess the value of the benefit received by the college. And his view was it would be most consistent with statutory policy for that to be assessed on the basis of a market rate for an occupying lease, so not a reference to a hire purchase contract. Now, it doesn't follow from that it would be inconsistent with policy to require SFM to repay what in substance amounted to borrowing costs. Indeed, the position is the reverse, because the statutory policy is that there could be no contract to borrow. And so, insofar as any payments have been made in connection with such a contract, they ought to be returned. Now, far from being inconsistent with the policy, that is indeed, in fact, what ought to happen.
Mr. Watkins, Mr. Salzedo, the court is very grateful to both of you and no doubt those who are working with you for the quality of the submissions which we have received. You'll be unsurprised to hear that judgments are going to be reserved. They will be sent to you in the usual way for any typing corrections, but no re-argument at all. It is highly likely that you will be asked to draft any possible orders for approval by the court, and it is also highly likely that hand down will be done electronically. If there is any concern at all, then my clerk, Ms. Tully, can deal with all matters if they can be referred to her. Our thanks to you and to those who've worked with you for all that has been put into this case.